We've got a quorum already, so please invite the administration in. We welcome the administration's team.
當局呢就上一次喺3月2號嘅會議
At the meeting on the 2nd of March, some issues were raised by members, and the administration's response is contained in paper 656 bracket 10. Mr. Charles Mock and Mr. Chen Chi-chun indicated at the last meeting that they would like to ask further questions, but then the two members are not here today. So any questions from other members? Sorry, can you please repeat your question? My question, last time, Charles Mock and Chen Chi-chun said that they would like to ask further questions on paper 656-1415 bracket 010. So I would like to ask other members whether they've got questions on the paper. No? And then concerning issues raised on the 23rd, and also the administration's response to the deputation's views. May I invite the administration to take us through paper 714 bracket 02. Yes, thank you, Chairman. I believe members have all got the paper bracket 02. In fact, this is our response to views expressed by the deputations. We are grateful to the deputations for their views. And there are a few points that we want to clarify for members. Last time, some members asked whether the HKMA would be able to be fair to local as well as non-local licensees. Now, with regard to SVF licensees and designated RPSs, the HKMA must regulate and supervise them in an equal and fair manner. Now, if an issuer wants to issue store value facilities, he or she has to apply for a license from the HKMA. Anyone who operates such a business without a license from the HKMA commits an offense. We have to make sure that all licensees are supervised by the HKMA, and the licensee has to establish or register a company and form a company in Hong Kong, and the principal business must be the issue of store value facilities under a license granted by the MA. And the MA's consent is required for any person to become a chief executive director or controller of an SVF licensee. And these people must be fit and proper persons to hold the positions concerned. And the licensee has to have in place appropriate risk management policies and procedures. And there is a need for the licensee to manage the risk and to have to take into account the interests of the relevant facility users or potential users. And also the SVF licensees have to redeem in full the total of the outstanding stored value as soon as practicable after being requested by a user. And even if the systems are outside Hong Kong, we require the licensee to have a company in Hong Kong, to have its business in Hong Kong, and to obtain a license from the MA. And if an issuer operates business which jeopardizes the interests of the users and prejudice the interests of Hong Kong as an international financial center, then the license may be revoked. We require all issuers, both local and non-local, to obtain a license. And the MA can join hands with overseas regulatory bodies to carry out operations. I think the important message is that if the issuer wants to operate a business in Hong Kong, then he must obtain a license. And concerning the place of issue, the place where the service is provided to the users, the content of the statement in the advertisement, and so on and so forth, all these will be taken into account in deciding whether a stored value facility is issued and is operated in Hong Kong. And what if there are SVFs which are not targeted at local users, and the SVF is not for purchasing or retail activities in Hong Kong? And Hong Kong people can have access to the SVF via the internet. Is there a need to obtain a license from the HKMA then? Now, these are not regarded as being issued and operated in Hong Kong. Now, if there are unlicensed SVFs operating in Hong Kong, under the bill, the HKMA can carry out joint operations with overseas regulatory bodies. And of course, for those who use a facility that is not licensed in Hong Kong, they have to be mindful of the risks concerned. With regard to the suggestion that there should be more regulation concerning the advertisements associated with such facility, then we'll look at how we can step up regulation. So that's in relation to para 127 of paper 02. Last time, deputation said that we should support market development and financial innovation. In fact, we can see that in fact there are many new SVFs and RPSs in the market, and we want to support market development and also financial innovation. And so we think there is a need to build in some flexibility in the bill, and we also need to be more forward-looking. So we should not impose unnecessary restrictions on future settlement and clearing systems or formats. We have to encourage innovation, and so concerning the operation of a certain clearing and settlement system, the format, the transmission of data, and in fact this is the open data interchange technology mentioned by a few deputations at the last Bills Committee meeting. So we do not propose to prescribe or preempt a particular choice of format, standard or technology in relation to the operations or data transmission of a designated system or an SVF scheme. What we need to ensure is that there should be safety and efficiency in terms of clearing and settlement. And so we think there is a need to build in some flexibility. And there is no need to prescribe or preempt a particular choice of format or technology. And some have said that we should not create unnecessary barriers for small and medium-sized players. We understand this concern. And so for SVF with limited usage and a float size of less than 1 million Hong Kong dollars, they will be exempted. Single-purpose SVF will also be exempted. Concerning retail payment systems, the bill seeks to empower the MA to designate an RPS if any significant disruption to or any significant inefficiency in the RPS are likely to result in monetary or financial stability of Hong Kong or the functioning of Hong Kong as an international financial center being adversely affected. And so small and medium-sized RPS operators will very unlikely be qualified for designation by the MA under the bill. Last time we told members that the FS in his 2015-16 budget announced that a steering group on financial technologies or fintech will be set up. So in the steering group, we will be looking at ways to promote fintech in Hong Kong and how to promote Hong Kong as such a hub. Last time, deputations made suggestions in relation to the development of fintech, and we think that these suggestions can be taken forward outside the context of the bill. Last time, Mr. Charles Mock made some comments on the liabilities on internet service providers. The provision doesn't impose a duty on an internet service provider to verify the content and accuracy of the promotional or advertisement materials provided by an SVF issuer. And then concerning other regulatory systems, we are studying those provisions at the moment. And so when we reach section 8C in our clause-by-clause study, then we can have a more detailed discussion. We've annexed to paper 02 our response to written submissions and comments given by deputations to the Bills Committee. And so, Mr. Chairman, I can now answer members' questions.
Question time for colleagues. Mr. Chan Kam Lam, 4 minutes each. Thank you, Mr. Chairman. I recall that at the last meeting, when the deputations expressed their views, Octopus made it very clear that in this bill, they're almost the sole body being regulated. I'd like to ask the following question. Given that scenario, Octopus can only handle a very small sort value, $1 million. And for each added value, it will be, say, $50, $100, and so forth. Insofar as banking business is concerned, it has only a very small market share. If it is treated like a bank card, there are not that many uses. I'd like to know whether it is the sole body being regulated by the bill. Can I have some explanation? Mr. Chairman, will absolutely not say that under the bill, Octopus will be the sole body being regulated. As for the exemption for small and medium-sized enterprises and operators, we're talking about the total value of all the cards. Given the business of Octopus and its broad coverage and popularity, it will definitely be regulated by the bill. Under the banking ordinance for the multi-purpose SVF, Octopus is being regulated already. It's just that for the multi-purpose SVF under the banking ordinance is being transferred from that framework to this framework. And Octopus won't be the only body being regulated. In the market, we have different operators, mostly providing online payment services. They will also be interested. Their existing modus operandi will highly likely fall within this regulatory framework. We'd like to send a message to Octopus and the Bills Committee that this bill does not target Octopus. Apart from Octopus, in fact, on the Internet, there are similar tools doing more or less the same things as the Octopus. They are providing a number of services. It's just that they're not in the form of a card, so we cannot regulate them. And in future, they're going to be handled by this ordinance. So there's no question of a sole body being regulated. Mr. Chen Kam-lam, given the situation of Octopus, they're regulated under the financial and economic regulatory framework. But given these new provisions, they may be covered by the provisions in the bill. Is that what you meant? I'd like to thank the honourable member for his question. Basically, at the moment, their businesses are regulated by the existing banking ordinance. Even if they're not going to further develop, given their present modus operandi, they will be regulated by this clearing and settlement systems. That is the bill. So even if they don't further develop, they will be regulated by the ordinance. Mr. Ng Leung Sing. Thank you, Chairman. May I ask something about paragraph 11 of the paper? That is the establishment of the steering group on financial technologies, FinTech. This is related to the future framework. Now, after the establishment of the steering group, who will oversee it and who will be regulated by it? Under which official will it be? I mean directly. And what types of products will be regulated by it, and what functions will it play? Can we have some reference information? Thank you, Chairman. Thank you for the question. If I remember correctly, 1 to 2 weeks ago, the government issued a press release in this regard. Under the Financial Services and Treasury Bureau, we responded to the Financial Secretary's budget by setting up the Steering Committee on Financial Technologies, FinTech. This is under the personal leadership of Professor Chan Ka-keung, the Secretary for Financial Services and the Treasury. There will be official representatives and representatives of the industry, the financial services industry, the technology industry, the IT sector, the cyber port, people who have deep knowledge about financial services. The steering group has just started its work. We hope that in the coming year, we can respond to the request of the FS. In the coming year, we'll explore with members of the sector these financial developments and what business opportunities will be given to Hong Kong and what support we can give to such development, what long-term development there will be, what more or less we should do, how should we handle the development of financial technologies in future. So these will be our tasks in the coming year. Well, the steering group has just been established. After we have attained certain progress, we'll explain to the public. On this, I'd like to ask this. On the mainland, we heard that there are certain online financial items. Here you mention development potential and possibilities. Will there be cross-boundary developments? Will you collaborate with relevant businesses, personnel on the mainland? Should there be more connectivity with the mainland? Yes, that will definitely be done. There's huge potential for the further development of the financial technologies. Hong Kong is not alone insofar as IT and financial services developments are concerned. There must be synergy between us and other cities. What Mr. Ng mentioned would definitely be raised in the steering group. We'll definitely respond to Mr. Ng's comments and reflect those views to the steering group so that they understand the latest trend. Mr. Sen Chong Kai, well, last time we asked about certain issues. I believe paras 1 to 7 of the paper provided responses, but there are still certain points that I don't understand. The PAS said that there will be sufficient provisions in the bill to cope with these developments. Say, if the objective of a particular business is not in Hong Kong is not its target, maybe an international establishment proactively makes use of the systems. Well, you can regulate advertisements on Hong Kong's websites, but maybe they place advertisements on international websites, so you may not be able to regulate them. That's why last time I asked whether or not you would regulate these, because all monies start with the banks. What about those unlicensed clearance and payment or settlement systems? Will there be any interface between them and those under your regulation? I don't understand this issue after reading paras 1 to 7 of the paper. Mr. Liu, thank you for the question. I think Mr. Sin's understanding is correct. We mainly target those operating clearance and settlement businesses in Hong Kong for soliciting of clients locally and also at the retail level, they'll definitely fall within the regulatory framework. Hong Kong people don't just enjoy financial services locally. As Mr. Sin said, they're very internationalized. Out of business needs, they may be using such services elsewhere in the world, and so they will be regulated by the relevant jurisdictions and regulatory bodies. For extraterritorial facilities and tools, if there's an interface with their counterparts locally, what we can regulate is banks and local clearing and settlement systems. Under this ordinance and this bill in future and the banking ordinance, those institutions under our regulation, those institutions as well, will operate with a sound and perfect system. Say if there is a gambling website overseas, can they handle local accounts and local banks? Can local banks and local accounts be connected with them for clearing and settlement? In this bill and the ordinance, we have sufficient provisions to regulate targets of the MA, banks, payment institutions, clearing and settlement systems, and we can order such licensed establishments to stop operating. As we regulate extraterritorial services, when we explain to the public, we'll say that extraterritorial banking services or clearing and settlement services, if they're not regulated by a local regulatory body, if members of the public don't know where the line lies, we do conduct education to explain to the public the scope of our regulatory regime. So when extraterritorial services are used, users will have to pay attention to the risks involved. Mr. Kenneth Leung, I'd like to ask about the personal data privacy ordinance. I think there is a section regulating the transmission of data and information in an extraterritorial manner. That's Section 33. I'd like to know whether Section 33 has already been implemented. Has it commenced? That is my first question. Mr. Chairman, I don't have Section 33 of that ordinance with me here. I understand that clearing and settlement systems are regulated by other pieces of legislation, like the privacy law. Mr. Leung mentioned Section 33. If I remember correctly, that has not taken effect yet. Here, I don't have the section, so I can't offer further information. Section 33. Section 33 is about cross-boundary transmission of personal data. Well, that ordinance has been enacted for over 10 years, but we never know when this particular section will take effect. For clearing and settlement systems, very often they involve cross-boundary transmission of personal data. Well, the whole ordinance has been enacted, but for Section 33, there's no designated date of commencement. So when personal data are to be transmitted beyond Hong Kong, how will that be regulated? Under the privacy law, there is such a regulating section. Why don't you do some coordination work? Because up to this moment, Section 33 has not commenced. Maybe, broadly speaking, this is not within your jurisdiction insofar as this bill is concerned. But overall speaking, you have to consider that as well.
Yes, Chairman. Now, as Section 33 has yet to come into being, and there is no need for stored value facilities to comply with Section 33. But then we have other provisions to make sure that SVFs operate in a safe and prudent manner. In fact, in Schedule 3, we do require that the issuers or the licensees must be prudent and sound, having regard to the purpose, business model, and operational arrangement of the scheme. And they must satisfy the HKMA that the interests of the users and potential users must not be jeopardized. And that's, in fact, in para 4 of my reply. So even though we don't have Section 33 of the Personal Data Privacy Ordinance, there are still other provisions to ensure that users in Hong Kong will get sound and prudently operated service. And then Section 33 of the Personal Data Privacy Ordinance is not really within our remit. And I can only relay Mr. Leung's concern to the CMAB. Mr. Charles Mark, I thank Mr. Liu for responding to my concern concerning Internet connections. Mr. Liu said that there would not be any penalties in relation to Internet service providers. But then Section 8C talks about providing network or Internet portal access. So to a certain extent, Internet service providers are being singled out. And then concerning advertisements, Chairman, we've recently studied the Human Reproductive Technology Bill, and that bill talks about dissemination of information. So the provision in this bill and in that bill are similar but not the same. And then the in the copyright bill, there is the safe harbor provision or arrangement. In other words, after the ISPs have taken certain measures, they will enjoy the safe harbor arrangement. But then we don't know whether the Internet service provider will have to shoulder certain liabilities. And I can remember that in the Human Reproductive Technology Bill, or in that context, the legal advisor asked whether it would be against the law to provide a hyperlink or to design an advertisement. In that Bills Committee, the Department of Justice told members that he really didn't know. It really depended on the circumstances of the case and how the how the judge viewed the matter. So concerning a hyperlink, is that okay? Because ISPs do not know what the requirement is. And so in that Bills Committee, members asked the DOJ to give a comparison of relevant provisions in different pieces of legislation. I'm worried that in each bill we have in brackets words like internet service providers or website operators. So ISPs do not know what they can do and what they cannot do at certain times. So ISPs are very concerned. So we have concerns about this provision in this bill and similar provisions in other bills. I think you need to very clearly tell ISPs what you're proposing to do and what you want ISPs to do. I'm just worried that ISPs simply do not know what are expected of them. Thank you, Chairman. Yes, I understand that in different pieces of legislation there are different regulatory contexts. So for this bill, we are not proposing any additional or extra conditions for ISPs to comply with. But of course, they cannot knowingly promote or assist another person in issuing or facilitating the issue of an unlicensed store value facility. So in other words, they can't promote or assist another person in carrying out some unlawful business. We've spelled out those persons who will be particularly concerned about the possible liability. And if we need to have further amendments on 8C, we can discuss those amendments with Mr. Mock when we come to that section under clause-by-clause examination. Now, Mr. Sin Chung Kai did raise his hand, but then he's not in the conference room at the moment. So I wish to follow up. Say in the UK, you buy an Oyster card in the UK for taking the underground, but then of course you can top up the value on the internet. So the Oyster card was not purchased in Hong Kong. I merely top up the value on the internet. And in fact, in Hong Kong, not many people visit London often, so not many Hong Kong people do have Oyster cards. So is it that you're not going to regulate this business in Hong Kong? Because in fact, very few Hong Kong people use Oyster cards. Mr. Lee? Yes, thank you. We will not regulate Oyster cards in Hong Kong. There are several reasons. Firstly, Oyster card is a single purpose and not a multi-purpose SVF. But that's really not the main reason. It's true that many Hong Kong people are very internationalized. They may have overseas bank accounts, they may use overseas SVFs in overseas countries, but then they may top up the value in Hong Kong using the internet, and we will not regulate such activities. And we will not disallow banks from providing the payment service. So we are only trying to prohibit unlawful services. So Hong Kong, people are internationalized. When they visit Japan, they may buy store value cards there. But of course, at the moment, we can't top up the value of Japanese store value cards on the internet. It really depends on the circumstances of the case, Chairman. Now, if a card is not used in Hong Kong and it doesn't accept Hong Kong the Hong Kong currency, and Hong Kong people buy these cards only when they are on overseas trips, then we will not seek to regulate these. All right, do members have any further questions? No? The Legal Services Division issued paper 714/03. It's in fact a letter to the administration to seek clarification on certain matters. So the administration has provided its response, and it's in paper 714/04. I think we can deal with these papers when we do our clause-by-clause scrutiny. All right, if members have no further questions on these papers, so can we now start clause-by-clause scrutiny? Mr. Liu? Yes, thank you. I would like to thank the clerk for having prepared a marked up copy. Should I use the marked up copy or the blue bill? Do members have the marked up copy? It's paper 615/1415/01. Yes, I think, Chairman, we can refer to the marked up version at an appropriate time, but I believe members have got the blue bill, right? So can I start? Yes. Chairman, I think I will deal with both versions, Chinese and English together. Long title. To amend the Clearing and Settlement Systems Ordinance to empower the MA to designate and oversee certain retail payment systems, to regulate matters relating to the issue of stored value facilities, including the setting up of a licensing regime, to provide for an investigatory regime and the power to impose sanctions regarding contraventions of that ordinance, and to make related amendments. Members, any questions? No? Please continue. Thank you. Clause 1. Short title and commencement. This ordinance may be cited as the Clearing and Settlement Systems Amendment Ordinance 2015. Most of the provisions will come into operation with the passage of the bill. But then concerning applications and the processing of licenses, they will come into operation 1 year after the passage of the bill. This is to allow people time to put in applications and to allow time for the HKMA to process the applications. So, so much for clause 1. And then clause 2, enactments amended. You can see the enactments that will have to be amended. And then may I refer now to page 1 of the marked up version. We need to also amend the long title of the ordinance. At the moment, we only cover clearing and settlement systems involving huge amounts, but now we will include payment systems and also stored value facilities. So this is clause 3, and you can compare this with page 1 of the marked up copy.
Any question? No, please continue. Then clause 4 of the bill, that is Section 1 of the ordinance. After the enactment of this bill, we will no longer call it the Clearing and Settlement Systems Ordinance. It will be known as Payment Systems and Stored Value Facilities Ordinance. This will more accurately explain the coverage of the bill. Any question? Please continue. Then Clause 5 of the bill, which is to handle Section 2 of the ordinance. We have a whole series of definitions which will be handled together. It is worthwhile to mention that we'll change the definition of designated systems under the existing ordinance, such that retail payment systems will also be covered, not just clearing and settlement system. So designated clearing and settlement system and designated retail payment system. For senior officers, settlement institutions, and so forth, will add in designated system, and how we should interpret those definitions. Take, for example, for settlement system, at the moment the ordinance only targets clearing and settlement system for huge amounts, huge sums. Now we've added in a new definition that is on page C69. Right at the very beginning, we say that in relation to retail payment system means a person who, for the purposes of the operating rules of the system, is responsible for the operation of the transfer, clearing, or settlement functions of the system or any other related functions. We asked whether or not only local systems will be included or extraterritorial systems will also be covered. We're told that when members of the public use their credit cards, they'll use cross-boundary systems for clearing or settlement. So whether or not the clearing or settlement payments are made locally or elsewhere, they fall within this regulatory framework. Will you consider make this clearer in the bill? Chairman, thank you for your question. The existing Clause 3 of the bill, I'll come to that in a moment. The application of the bill will cover not just local systems, but also extraterritorial systems. May I refer you to page 11 of the marked up version. To respond to your suggestion, Chairman, will propose to change the title to cover not just local systems, not just local facilities, such that users of this bill will clearly understand that if the clearing and settlement system, be it huge sums or retail amounts, extraterritorial clearing and settlement businesses will be covered. In particular, even at present, not only Hong Kong settlement facilities will be involved, but also those beyond Hong Kong. For the application of the retail facilities, I agree with the chairman that it's more helpful to the users if you can make that clearer in the definition. As for Clause 3, You are amending the subtitle, not the content, not the body. So it's better to actually clarify this in the definition. So government, would you please go back and consider this? Yes, we'll go back and do so. Because you have to specify that the clearing and settlement are not just done locally, but elsewhere. Mr. Chairman, you mentioned the definition for settlement systems and the coverage of retail activities. We'll go back and examine whether or not we need to make it clearer that by retail activities we don't just mean those in Hong Kong. We'll go back and examine this. Colleagues, any more questions? No, please continue. Still we're on clause 2. The definition of system operator. System operator in relation to a clearing and settlement system means a person for the purposes of the operating rules of the system is responsible for the operation of the clearing or settlement functions of the system, and also in relation to a retail payment system. What do you mean? In the bill, we have a definition for retail payment system. May I refer you to the blue bill C75 and C74 of the Chinese version. So the retail payment system means a system or arrangement for the transfer, clearing, or settlement of payment obligations in relation to retail activities, and also includes related instruments and procedures. Terminals will be covered. And then for the system operator, we also mention in relation to a retail payment system, a person who is responsible for the operation of the transfer, clearing, or settlement functions of the system and any other related functions. Please elaborate on this. Well, system operator, its definition has two parts, Part A and Part B. My question is for B, Roman 2, any other related functions. But in bracket A, this person is not included. So why should there be such a drafting difference? PAS, thank you, Chairman. Well, we mentioned this in our paper. Perhaps I should explain this. For clearing and settlement systems, A covers the huge sums of clearing and settlement. That is, interbank transfers of huge sums. So, only the functions of clearing or settlement will be involved. Other functions won't be involved. But for bracket B, for the retail payment system, given the present business practice, the person may be responsible for the collection of invoices as well as the operation of computer terminals. So, to play safe, we add in Roman 2 any other related functions. This is to make the definition of system operator clear and perfect. Mr. Ng Leung saying, I don't have major problems with the other issues. In a moment, we'll discuss senior officers or officer. Overall speaking, let me say something on behalf of the Hong Kong Association of Banks. You've received our submission for stored value facilities. The relevant banks do hold a license. they shouldn't be regulated by other pieces of legislation other than the banking ordinance. Now, if this is within the regulatory regime for banks, that is the banking ordinance, then you should not have something additional. That is, for the banks, we already have the banking ordinance. Have you exchanged views with the HCAP? That is, will banks be covered by the bill? P.S. Thank you, Chairman. Thank you, Mr. Ng. In the past 2 years, the Financial Services and the Treasury Bureau and the Hong Kong MA had various opportunities to brief the HCAP on the content of the bill and to consult them. We did adopt some views from the HCAP. In the main, licensed banks are already under the consolidated supervision of the HKMA. So there is this question of whether or not banks should take out another license for their clearing and settlement systems. In our opinion, banks may be involved in settlement activities or the issuance of SVFs. Well, in the bill, we do say that banks don't need to take out another license. They're deemed to be licensed for operating such businesses. But not all banks operate clearing and settlement systems or businesses. But if they do so, we have to ensure that their practices, as mentioned at the last meeting by certain companies that attended, we have to ensure that the regulatory framework and environment are the same for both. So if a bank now operates clearing and settlement activities or businesses, then it's already under the regulation of the Clearing and Settlement Systems Ordinance. Some provisions of the ordinance apply to them. So there is to be consistency. So be it a bank or a non-bank operating such businesses, there will be a fair and equal regulatory framework. And for certain regulatory provisions, they don't target banks. As Mr. Ng pointed out just now, some of these regulatory provisions are already in the banking ordinance. So certain provisions in this bill do not apply to banks. This is to reduce to a minimum the number of provisions applicable to banks. But insofar as regulation is concerned, we have to give equal treatment to everybody, be it a licensed bank or other licensees. They should be put under the same regulatory framework. Under the Hong Kong MA, they implement the SFO, the MPF ordinance, and the insurance ordinance. We cannot say that the banking ordinance alone is enough. Yet I note the comment of Mr. Ng, and the Hong Kong Association of Banks also reflected that view to us. And which provisions are not applicable to banks, there must be reasons, and I'm ready to explain to members. Your explanation just now carries a number of details, and if possible, please reflect these to the HCAP in writing. I agree that there should be consistency. P.S. Is that all right? We are precisely doing this. Before Easter, the HCAP, through your secretariat, submitted a submission to us. I hope that at the next meeting, we can let you have a paper on our responses to each and every point put forward by them. And then we'll explain why certain provisions should be applicable to banks and why the banks are exempted from certain provisions. And they mentioned that in their submission. We'll explain all these points to you.
Right, other questions? No? Please continue then. So now we are on page C68, transfer order. Now, because we've included the regulation of retail payment systems, and so we need to say that concerning transfer order in relation to a retail payment system, it means an instruction that results in the assumption or discharge of a payment obligation relating to retail activities for the purposes of the operating rules of the system. And then we have a number of new definitions, including the deposit. Let's say, for example, if we buy an Octopus card, we need to pay a deposit, and that's the SVF deposit. And then safety, licensee, facilitator, efficiency. We are listing these out as an index to facilitate readers' reference. Then what is meant by issue? We have a definition here. It includes the operation of the facility by the issuer for use by the user of the facility after its issue. And then other definitions. They will be or they will appear again later. And then may I refer to C76, the float. This is important. This whole bill is about protecting the float of the users, and float means the stored value remaining on the facility but doesn't include any SVF deposit. This is because we have another provision on deposits. And in the schedule, we detail how licensees have to provide 100% protection or guarantee in relation to the float. And then concerning the other definitions, they will appear later in the bill again. Yes, let's continue. Clause 6, Chairman. 2A, 2B, and 2C. 2A. Now we have a very important definition. This is about the stored value facility. So a facility is a stored value facility if the facility may be used for storing the value of an amount of money that is paid into the facility from time to time and may be stored on the facility under the rules of the facility. And B, the facility may be used for either or both of these purposes as a means of making payments for goods or services under an undertaking given by the issuer, and as a means of making payments to another person given by the issuer. So this is the definition of a stored value facility. All right, any questions? Please continue then. Legal advisor, please. Thank you, Chairman. Concerning interpretation stored value facility, it says the undertaking is to pay a third party, but then it doesn't say anything about the purpose of making payment to a third party. And so my question is, do you need to spell out the purpose of making a payment to a third party? Yes, we've looked at the use of SVFs in Hong Kong. SVFs are mainly used for purchasing goods and paying for certain services, like hotel services. 2A, 1B says that the facility may be used as a means of making payments for goods or services under an undertaking. And then sometimes there may be the transfer from one person to another person. Say after a meal, I transfer my share of the bill to another party, and then the father may transfer some money to the son. And so we don't think there is a need to spell out the purpose. The purpose is really not important. What is important is that the facility can allow payment, and it's a stored value facility, whatever the purpose is. And so we don't think there is a need to spell out the purpose of one person making a payment to another person, because the purpose is not important. Anything to add? No. And then another question in relation to 2A. Now say, in order to attract more users, then the SVF operator may offer bonus points, mileage, or interest if a certain amount of money is stored for a certain period of time, and that may be like a savings account. And if that's the case, then will such arrangements be subject to this bill or to the banking ordinance? Yes, Chairman. There will be some amendments to the banking ordinance. And concerning the deposit or the float in the stored value facilities, they do not fall within the definition of savings under the banking ordinance. And in fact, at the first meeting, we, in reply to Mr. Sin's question, said that that would not be regarded as savings. Yes, some stored value facility operators may offer some incentives, rewards for the users. We have no intention to prohibit these, but the HKMA in its regulatory work will take into account the nature of the scheme, the mode of business, and if the HKMA thinks that the business or the nature of the business has departed from the core function of a stored value facility, then the HKMA will intervene. The banking ordinance states very clearly that only banks can take in deposits. So the HKMA is given enough power. But we don't think there is a need for us to amend the definition here. Yes, please continue then. And subclause 4, or section 2A bracket 4, we've emphasized many times that a single-purpose stored value facility, like a cake coupon or a coffee coupon is not a stored value facility for the purposes of this ordinance. And so a single purpose stored value facility will not be subject to this ordinance, though it may be subject to other ordinances. And then we have here the definition of a single purpose stored value facility. It's issued by the issuer for buying the goods or services provided by the issuer. So in other words, the facility cannot be used to buy other things. The facility can only be used to buy goods and services provided by the issuer. The next one, bracket 6. A facility may be in physical or electronic form. In other words, a facility is not only the octopus card, the card itself. And money, or a reference to money, is a reference to money in any currency or any declared medium of exchange. And I will later explain to members what is meant by a declared medium of exchange. Perhaps I can pause here to see if members have got any questions. Legal advisor. Single purpose SVF. I didn't raise any point about this in my letter, but I want to ask this. It says that it's used to purchase goods or services provided by the issuer. What if the issuer provides both goods and services? Say the issuer is a shop which provides both goods and services, and will that still be caught by this definition of a single-purpose stored value facility? Mr. Lee. Chairman, basically, it still falls within this definition if the goods and services are provided by this same issuer. We'll still define the SVF as a single-purpose SVF. But if it's a multi-purpose stored value facility, then the goods or services are basically provided by another party. But here, we're talking about goods and services provided by the issuer, and we regard the facility as a single-purpose facility. All right, members, any questions? I think we can continue. Yes, now we're on page C83 of the English version, the interpretation of facilitator. Last time, we received some questions in writing as to the meaning of facilitator. And in fact, there is a definition of facilitator under the definition of multi-purpose stored value cards in the banking ordinance. Because some SVFs are not issued by one issuer. Say, for example, Mondex. It held the value and the float, but different banks issued their respective Mondex cards. So in other words, it's a two-tier system. The banks issue the cards, but then above the banks, there is the company called Mondex operating the Mondex card. And so we need to include such facilitators. Say, for example, Mondex, strictly speaking, was not the issuer. It merely held the value and the deposit, but it was operating the Mondex scheme.
So for the definition in 2B, we're actually modeling on the banking ordinance in relation to the regulatory system for store valued facilities. So we've transferred the definition for facilitator here. This is to govern a two-tier card issuing system. For those who help the SVF issuer by providing services, this is not applicable. So for 2B1, it makes it very clear that the facilitator must provide valuable consideration to the issuer for the clearing and settlement of card issuance. As for the supportive personnel, say the distributors of SVF services, if there's no valuable consideration, they're not governed by 2B. So this is actually taken out from the banking ordinance. I think the industry should be very clear about this. If you refer to the example of Mondex, this is not commonly seen. So 2B won't be invoked very frequently. But to play safe, we've included it here. Colleagues, any questions? Legal advisor, any question? All right, please continue. 2C. The monetary authority may declare medium of exchange. Just now, I refer to bracket 6B. For the payment facility, it will usually be currencies of different denominations. And in future, we'll have to consider further developments in terms of financial innovation. So in future, if the stored value is not in the form of currencies, but in the form of an exchange media, then the clearing and settlement facilities may be able to bypass the regulation of the bill. So here we empower the monetary authority to, by way of gazetto, declare a thing to be a medium of exchange for the purposes of this ordinance. In other words, well, can you use plainer language? Well, for example, virtual commodities like Bitcoin. Well, last time at the electoral meeting, we mentioned Bitcoin. At the moment, it's not very popular in Hong Kong. We don't see Bitcoin octopus or Bitcoin store-valued cards for payment. But in future, if virtual commodities or virtual currencies that are not normal currencies issued by an issuing bank, but may impact on the stability of the banking system, the monetary authority may declare it a medium of exchange. Then for the operator of the SVF, using this medium for exchange will be governed. Take, for example, a card using mileage as a basic unit. Can you declare that a medium of exchange? If the calculation of mileage makes it a widely used payment tool or facility for purchase of commodities, goods, or services, then there is a chance that may be declared a medium of exchange. I mean, for a card using mileage as the basic unit. But that must be widely circulated. Mr. Chen Chi-chin, has the MA announced any such medium of exchange? Can you give us an example? Do you mean mutual exchange? That is, transfer into points and then points back to cash. Well, let me cite an example. Say my card is not to store money, but store points. I store points in this card, and these points can be used for multi-purpose spending. P.S. Thank you, Chairman. Thank you, Mr. Chan. Well, this bill has not been enacted yet. You don't have this in other pieces of legislation? That's correct. After the enactment of the bill, if that really happens, as Mr. Chan said, points or mileage or virtual currencies are used as medium of exchange, not for a single purpose, but broadly in circulation in the market that can be used to purchase goods or services, then the monetary authority may declare that to be a medium of exchange for the purposes of this ordinance and be regulated under this bill. At the moment, we don't have such examples. In future, if we have such a scenario, we'll make use of this provision. Medium of exchange. Do you have a statutory definition for it? Is it a dual direction exchange? That is, the points cannot be changed back to money, but can only be used to purchase commodities, goods or services. Well, the platform for exchange is very high. It must be broadly in circulation before you can call it a medium of exchange. Not just purchase in money, but usable and applicable in many jurisdictions for the purchase of goods or services before you can call it a medium of exchange. Well, basically, at the moment, it's the currencies in use. So this provision is a backup only. Yes. That is, this is a medium of exchange even for general transactions. At the moment, for SVFs, we only use currencies, but we have to have long-term consideration. So this is just a backup provision for future use. Well, I don't have any supplement. This is only to prepare for what may happen in future. P.S. Well, we can move on to Clause 7, which amends Section 3. I mentioned its heading just now. The heading will make it clear that designated system applies to what? Under Clause 3 of the bill, large sums of exchange are involved. So we want to change the heading to make the contents clearer. But the contents have not been changed. But given the comment of the chairman and the legal advisor, we'll look at the term retail, whether or not we should include expressly extraterritorial retail. Any questions? No? Please continue. I won't dwell on clauses 8 and 9 in detail because they're about the headings. As for clause 10, this is mainly to add in new provisions to allow the Hong Kong MA to designate clearing and settlement systems as well as retail and payment systems. This is mentioned on page C87 of the Blue Bill. That is 4.2. A. It is material to the monetary or financial stability of Hong Kong or material to the functioning of Hong Kong as an international financial center, or having regard to matters of significant public interest, the monetary authority is of the opinion that the system should be so designated. So the threshold is in fact very high. And the ensuing provisions further interpret this provision. May I refer you to 4.2b. It meets the description for a clearing and settlement system. It accepts for clearing or settlement transfer orders denominated in Hong Kong dollars. For a retail payment system, it accepts for transfer, clearing, or settlement transfer orders denominated in any currency or declared medium of exchange. And we'll add in a new section, a subsection, to define what's meant by significant public interest. That is, if the system does not operate effectively, the financial stability of Hong Kong or monetary stability of Hong Kong or the functioning of Hong Kong as an international financial center may be affected. Then for 4.1a just now, financial or monetary stability may be affected. So this is to further explain the definition of monetary or financial stability. For the new 3a, we try to explain significant public interest. We're worried that if these systems become ineffective or have operational problems, public confidence in these systems may be undermined. Public confidence in the monetary system of Hong Kong may be undermined, and the financial and economic systems may also be disrupted. So these will be viewed as of significance for the Hong Kong MA to designate the systems for regulatory purpose. Any questions? Legal advisor. Thank you, Chairman. My first question involves the Chinese version 4.3, the new 4.3. That is, if the system is subject to serious or material impact. For bracket 3, you use 重大干擾. Of course, you also use 顯著, but for 干擾, you use 重大. Why is it necessary for such a change? 顯著 and 重大, are they different in terms of extent or degree? Colleagues from the drafting division? Yes, the draftsman. In our opinion, under this circumstance, the use of 顯著 will make it more specific in terms of the Chinese language is concerned. What is 顯著 in English? Significant. What about 重大? 重大 is equivalent, should be important in our view, or something similar. Because the term significant must match with efficiency, so 顯著 should be more appropriate. Our legal advisor. Thank you, Chairman. Why am I asking this? Because for significant public interest, they use the word 重大. As for 干擾, they use 顯著. So I'm considering whether in the Chinese language, 重大 is more serious. Well, when they considered this change, did they consider the change in extent or degree? No, no change in extent or degree. Is just a matter of collocation because 重大 is linked with public interest. That is to match efficiency. In the Chinese language, both terms mean 大. Mr. Ng Leung saying, I'm also asking about this. One is 重大 public interest. Well, public interest is very often used. So if you use 重大, do you have any objective method of assessment? Will it be just a subjective feeling on the part of the monetary authority? Above the monetary authority, is there any other manager or official making the final decision? Because this is something to do with public interest and 重大 public interest. I would like to know the details of your deliberation.
Yes, thank you, Chairman. And I thank Mr. Ng for his very meaningful question. In fact, for 4A, and I'll be going to that soon. When we look at what is meant by important public interest, and then whether the disruption is significant or what, I think we need to look at the factors in 4A, page C93. For example, the estimated aggregate value of transfer orders transferred, cleared, or settled through the system in a normal business day. And so, in considering whether there is significant public interest, the HKMA will look at the size of the operation. So we are stating here the factors that the HKMA must take into account. So these are the directions to be followed by the HKMA. Mr. Chan Kam Lam. Here it says that the disruption will have an adverse effect on financial stability. What if there is any a good impact on financial stability? Do you think the description here is really accurate? Yes, Mr. Liu. Thank you, Chairman. Thank you, Mr. Chen. In fact, under 4.1, we define the systems to be regulated. So the normal operation is important for the proper functioning is material to the monetary or financial stability of Hong Kong. And then as to what is meant by adversely affecting the monetary or financial stability of Hong Kong, we say here in subsection 3 that if the occurrence of any significant disruption to or the presence of any significant inefficiency in the functioning of the system is likely to adversely affect the monetary or financial stability of Hong Kong and the functioning of Hong Kong as an international financial center, then it is a system regarded as a system whose proper functioning is material to the monetary or financial stability of Hong Kong or to the functioning of Hong Kong as an international financial center. So the HKMA considers all the consequences and decides whether the system is important and significant for the monetary or financial stability of Hong Kong. And Mr. Chen, so in other words, is it that if a system can disrupt the normal operation of the market, and it is a system that is significant. We do not want order in the market to be disrupted. And if a system is inefficient and as a result, users are adversely affected and retail activities in the market are affected to a large extent, then such are regarded as important systems which have to be regulated. All right. Any questions? Then we can continue. For B, page C93 of the English version. The monetary authority may, in a notice published in the Gazette, declare the activities that are allowed to be carried out through the system. That's 4B. And then we have 5. About designation by the MA. The issuer or operator can have a 14-day period to make oral or written representations to the HKMA. And so we have this 14-day period for the issuer. Now section 5. For the RPS or the SVF, if the scale of operation has been reduced, if it is no longer a system which will involve important public interest, then of course the HKMA can withdraw the designation. And if the HKMA wishes to withdraw the designation, then the issuer, the system operator or the settlement institution will have 14 days to make oral or written representations to the HKMA. And the HKMA will make a decision as to whether the system is still important to the market and whether the designation should be revoked. All right, please continue. We're now on C99. Designated systems including RPSs. The operator or the institution has to provide information concerning the name, the address, and such information is important for the HKMA to exercise its regulatory function. And if the operator or institution fails in its duty, then it's an offense. And we think it's better to have the penalties here. So if the name and the address is not given to the HKMA, then there will be a penalty. Yes, members, any questions? Mr. Charles Mock. Chairman. say if a company has an overseas branch, then is it okay to just provide the address, the name or the address of any person? Now you know that there are of course some organizations which are non-local organizations, but you require a company to be set up in Hong Kong. And so is it that you require the correspondence address in Hong Kong? Say, for example, I may say that I do have a correspondence address in Hong Kong, but my main business is in another country, and so I will provide HKMA with an overseas address. So is it that I must provide HKMA with a local address? Mr. Lee, thank you, Chairman. If it's in SVF, then it must be a legal entity in Hong Kong, and so there must be an address in Hong Kong. But for an RPS, it may be primarily an overseas system. For example, the system of a credit card company, and in that case, an overseas address is acceptable. So, do you think you need to separate the case of RPS and the case of SVF? Legal advisor. Because for an RPS and SVF, the situation may be different. In some cases, an overseas address is acceptable. And what if the address of the headquarters is provided to you? Yes, Chairman. Section 6 is an existing provision. It's about the operator or the settlement institution of the RPS. And with regard to address, email address, or postal or mailing address, we haven't specified whether they have to be in Hong Kong or not. In fact, they can give us their overseas address. We don't think there is a need to state that overseas addresses are also acceptable. We haven't detected any confusion or so far, and after all, there will be guidelines issued by the HKMA in the future. And here we're talking about global organizations, credit card companies, and companies of this nature. It doesn't matter if an overseas address is provided so long as the operator or the settlement institution can be contacted. And then can I ask a question about the penalty? So if they do not give you the address within 6 days, or if they change the address and do not notify you, then there will be a penalty. I want to know whether such penalties are regarded as on the heavy side. Say if I am only late in the submission of the address by 1 day, and I may be fined $400,000 and imprisoned for 2 years. So how does this penalty compare with other penalties for other financial offenses? Because these are the penalties for systems involving huge sums of money, $400,000, 2 years imprisonment, and then $10,000 for every day during which the offense continues. These are maximum penalties, and the court will hand down the penalty depending on the circumstances. And also we have this defense provided here. Certain excuses can be regarded as reasonable by the courts. So it's we're really in fact copying section from section 41, and we don't think the penalties are too heavy or are too harsh. They need to inform the HKMA of the change in address within 6 days, because if we can't contact the organization, and if the system fails, then there can be very grave consequences.
So this request is not very harsh. There is such a requirement in the existing ordinance, so we do consider the requirement appropriate. Legal advisor, again on penalty. For bracket 3 and bracket 4, there's nothing for summary offenses to be convicted as well as its penalty. So why don't we have summary offenses here? DOJ or Hong Kong MA? DOJ colleagues, who can supplement on this? As Mr. Liu said just now, this provision is actually the original section 41. What was the policy consideration then? Would it be related to monetary stability? That's why the penalty is for indictment only. I believe that's a policy decision. What about summary procedures? Imprisonment involved? Well, usually for summary offenses, the maximum penalty may involve imprisonment. In a moment, I'll introduce 6A to you. Here we don't have summary proceedings because under the existing ordinance, we don't want to affect the operation of existing provisions. Usually, for these breaches, if it is criminal prosecution, will use indictment rather than summary proceedings. So, it's sufficient to have penalty for indictment. Legal advisor, to follow up on this, insofar as policy is concerned, for 6A, for unannounced activities, the severity may be even higher. Well, this is serious also, but not too different from 6A. For 6A, given your policy consideration, you actually have the freedom to change your original consideration for Section 41 under this bill. So if you had summary proceedings for that, why can't you have it here also? Yes, go back and consider this. Now for 6A, restriction on activities carried out through designated retail payment systems. Now, for designated retail payment systems, they can only operate businesses designated by the Hong Kong MA, and the Hong Kong MA has to be notified, and prior written consent is required from the Hong Kong MA. Otherwise, any new activity will breach the requirement here, and we have penalty for conviction upon indictment or on summary conviction. If an RPS has a new activity, then the prior permission of the Hong Kong MA is required. The Hong Kong MA may give consent to the new activities or attach conditions. And the operator and related institutions can have 14 days to give verbal or written statements to the MA. And the MA has to make a decision as soon as possible to notify the operator whether those activities will be allowed. If an operator operates businesses and activities not permitted by the Hong Kong MA, it constitutes a breach. And even with the approval or consent of the Hong Kong MA, if the operator breaches the additional conditions, that's actually against 7 here, and the penalty is similar. Well, if colleagues have no further questions, should we stop here? Because we just complete clause 6. Our next 2 meetings are tentatively scheduled for the 28th of April at 8:30 a.m. and the second one, the 12th of May at 10:45 a.m. So please mark your diaries. If there's no other business, meeting adjourned today. Thank you very much.